Lien is a right of a creditor to retain the goods and securities in his possession belonging to the debtor until the debt is repaid. It is a right of the creditor to retain a particular property belonging to the debtor until the debt is repaid. Funds deposited by the customer in the bank, the amount of deposit made by the customer in the bank till he withdraws that amount, the banker is having all the rights. Warm welcome to 5th Sem B.Ba student. The subject we're discussing banking law and practice. In our first session, we learned about the meaning of bank and the banker and the general relationship. In today's session, we are going to discuss about special relationship of a banker and the customer. I am Professor Rajesh L.R. from Department of Commerce and Management, Vidhyaashram, First Grade College, Temple of Excellence, MYSURU. In the previous session, we discussed about the meaning and definition of a bank, features of a bank, classifications of bank, functions, importance and definition of banker and relationship between banker and customer. In that general relationship of the banker and customer, we had a discussion in the previous session. There will be 2 marks question on the meaning or definition of a bank, features and classification of a bank. It may be for 10 marks, and combined function and importance, it may be for 10 marks, and banker and customer, it is for 15 marks question. So from this chapter, at least 1 2 marks question, 1 10 marks and 1 15 marks question will be there. Understand the concept easily. In the previous session already we have discussed, and in today's session we are going to discuss the continuation of relationship of banker and customer, special relationship. In that one, the rights of a banker and banker's obligation. These are the major 2 areas are there where we are going to discuss in the present session. What are the special relations we have here? Special relations we have rights of a banker and obligation of a banker. Under rights of a banker, what are the rights a banker is having? Right of lien, right of set off, right to appropriate payments, right to charge, right not to produce the books of accounts, right under Garnishee order. So we have 6 rights are there where the banker is having to control the concepts in his hand and obtain the things, benefits for the benefit of the bank as well as for the society, by giving the benefit only not for the customer, even for the society, and he should have the control on the debts whatever is providing to the customers. Rights of a banker. In that first right, we have right of lien. So what is lien here? Lien is a right of a banker by which he can retain any security coming to his possession. That's saying that when a customer pledges anything for the purpose of borrowing funds from the bank, so the banker is having the right coming to his possession, that whatever the pledging is taken and has taken the handover of that one, is having the right here. In that banker's general lien, what we have, lien is a right of a creditor to retain the goods and securities in his possession belonging to the debtor until the debt is repaid. For example, a customer is borrowing 10 lakhs from the bank here. The customer has pledged his property. So now the customer is debtor and the banker is creditor here. The creditor has all the right to get the possession of the goods till and in his name till the amount is repaid by the customer. That is called lien here. Types of lien, we have general lien, particular lien. Only we have discussed it. It is the right of the creditor to retain any property which has been pledged with the creditor. The debtor, whatever the amount is borrowed for that, has pledged the property with the creditor, and the creditor has all the rights till the amount is not paid by the debtor. It is a right of the creditor to retain a particular property belonging to the debtor until the debt is repaid. So, until the debt is repaid, the banker has all the right to retain the property or the pledged goods, whatever it is there, with the creditor. Conditions of lien. What are the conditions are there for the lien? So, first condition is take the possession of goods. Possession of goods lawfully obtained means he has to pledge properly, transfer the rights of the property in the name of the creditor. No agreement implied, debts due, security should belong to the customer. It's not like that I'm borrowing funds. I'm Mr. A here. I'm borrowing for 10 lakhs loan from the bank and I'm pledging the property of B. That cannot happen here. It should be in the name of the debtor only. The goods deposited for specific purpose, whatever it is there, that should be in a proper way. Exemptions to the banker's lien, safe custody deposits, securities left with the bank, and money or bills deposited for specific purposes, accounts in different capacity, and contingent debts, whatever it is there. So these are the special exemptions are there for the banker. Next, conditions when a banker can exercise lien. Goods are in his possession. When the goods are in the hands of the banker, he is having all the rights. Lien on title of the goods, transferring the title of the goods from the debtor to the creditor. Funds deposited by the customer in the bank, the amount of deposit made by the customer in the bank till he withdraws that amount, the banker is having all the rights. Life insurance policy and fixed deposit receipt. The fixed deposit receipt, whatever has been given by the customer to the banker till he withdraws the amount, the banker has all the right to use that amount and get the benefit for the bank. Banker's right to set off. Right to set off is very simple here, where the banker has a right to set the accounts of the customer when a customer is having two or more accounts in the bank, and one account will be showing the debit balance and the other account will be showing the credit balance. So you can set off and you can close that one of the account which is showing credit balance and maintain only one account in the name of the customer instead of having more than one account. Conditions to right to set off. Account should be in the same name and capacity. They're saying that one, if I'm the customer, if my name is Ram, and it should be in the name of the Ram only, not Mrs. Ram. So the name should be same. Amount must be debt. Debts must be certain. Right set off only to present debts. They're saying that one, only the debts which are in the present, not the past one, 10 years or 15 years before, whatever the debts are there as on the date of setting off the accounts here. No agreement. Notice should be given to the customer. A small letter or a information has to be passed to the customer stating that when you have A account and B account in your name, A account is showing 10,000 credit balance and 15,000 debit balance. We are going to set off one account here and we are going to have any one account. We are going to maintain A account and we are going to cancel the B account here. Automatic is nothing but when the accounts of the customer is going to set off directly, means when there is a death of the customer or when a customer is going to become the insolvent, automatically the account will be set off. On receipt of notice of assignment or on receipt of garnishee order, either death of the customer, insolvency of the customer, or on the receipt of garnishee order or on the receipt of notice of assignment by the banker to the customer directly, accounts can be set off by the bank. Banker's right of appropriation. Appropriation is nothing but if the customer has two or more accounts in the bank and if deposits his funds into his accounts, it is the duty of the customer to inform the banker to which account the money deposited and should be credited. If it is not, right of appropriation of money. If not, it is a right of, means they are saying that one, if I have an account of A account and B account and I have deposited 1 lakh here and I have not mentioned the account for which account it has to be. Like for example, account number 1721, 1741. If I don't clearly mention for which account it should be deposited, the banker has a right to deposit 50,000 or 75,25 or 25,75 as per the requirement for that particular account. He may apportion and he can deposit, transfer the amount to your account. If you clearly mention that either they're going to record it in the 1721 or 1741, the 1 lakh. Right to charge interest and other charges. The banker has a right to charge interest on the debts given to the customer or the services, or even to charge other charges for the services given by the banker to the customer. Like for example, when a banker is giving the statements, past statements or passbook entries or checkbook whenever is giving and is maintaining our account, he is having a right to charge a nominal amount for the customer. Some of the charges by the banks are interest charges, low balance penalties. If the customer is not maintaining the proper balance in his account, the banker has all the right for the low balance penalty that is going to charge. If I have don't minimum balance is not there, the banker has a right to charge the penalty. Debit card account maintenance charges. Whenever a new debit card is issued, they're going to charge 340 to 380 approximately by the bank for annual charges, service charges, commission, locker facility charges, ATM transaction charges, checklift charges, account closing charges, NEFT and RTGS charges, signature verification charges, card changes charges, wrong address charges. So these are the major charges what made by the banker to the customer, and the banker is having all the right to charge any one of the account charges for the event whichever takes place. Rights of a banker: right not to produce books of accounts. The banker has a right not to disclose the information of the customer to any third party or to any person who is not related to the customer, or even is related to the customer also. The banker doesn't have any right to disclose the information of the customer. Only the banker has a right to disclose the information of the account holder when he receives the notice from the court order. Only the amount what is outstanding on that particular date of notice, and not all the transaction. If the court orders properly, then only the banker has a right to provide the details of the customer of last 3 months, or else the banker doesn't have right to disclose any information. That's the reason the banker will never produce or disclose any information of the customer to a third party or an outsider. Right under Garnishee order. What is Garnishee order? To warn. Meaning of Garnishee order: it is an order issued by the court to the banker to stop the payment belonging to the particular customer. Generally, court issues such orders on request of the judgment creditor. They're saying that one, Garnishee order is an order issued by the court. They are warning the banker to make all the payments to be stopped, and they should not provide any facilities to the customer. You just block the account of the customer. It is given on the basis of the judgment creditor. Parties involved in Garnishee order: the person who requests the court to send order. Say there are three parties are there: A, B and C. B is the court here. A is a customer, money lender. A has borrowed 50 lakhs from C and has repaid only 30 lakhs and has not repaid the 20 lakhs and the interest. So C approaches the court stating that when Mr. A has not given the amount and even he has not paid the interest also, I want to send him a notice. So the banker, the B is going to send a notice to the A as well as to the bank stating that one, make all the payments stop of related to the customer A and don't provide any facilities for the A till the further order is issued. As per the judgment of the creditor, the account should be blocked. Parts in Garnishee order: order nisi, order absolute. The first order sent by the court to the banker, it requests the banker to stop. They're saying that one, they're going to send a notice to the banker. Initially, the first notice will be sent to the banker to stop all the facilities or the transaction, whatever we are supporting, or the operations of the account belonging to a judgment debtor. It is a final order issued by the court to the banker. If the banker fails to stand before the court or doesn't raise any objections in the court will issue order absolute. It is a duty of the banker to transfer the amount to the judgment debtor. They're saying that one, till the order is made particularly, and if the banker immediately respond to the order, or if the banker doesn't respond to the order, then order absolute, it is a final order will be issued by the court on the request of the judgment creditor, stating that the account should be stopped and blocked and the amount has to be settled to the judgment creditor, or else the amount will be transferred to judgment debtor. Conditions of the garnishee order: there should be credit balance in the creditor's account. Account should be in the same name. Already I have said you people. Rights of the garnishee order: to suspend the operation means to stop all the movements of the customer account. To inform the customer, immediately they have to inform the customer, we are going to block your account based on the court order. To advise the customer to open a new account. If the account is blocked, the banker can suggest the customer to open a new account. Banker can raise objection with the court. Banker can say that he can raise a objection, we cannot accept that on what basis the order has been issued. It is a duty of the banker not to pay the amount to the customer until bank gets order absolute. They are saying that till the notice, final notice given by the court, the banker doesn't have the right to give the settlement to the debtor, transferring the amount to his account. It is the duty of the banker to obey the order of the, it is all the duty of the banker to obey the notice served by the court in the name of the customer as per the judgment of the creditor. Funds or amounts not recovered by garnishee order. The identity of the debtor is doubtful. If the banker has a doubt on which customer the notice has been served, and it is going to be very difficult for them. And after serving garnishee order, deposits made by the customer, payments made by the banker before serving garnishee order. For example, there was huge amount was there before receiving the garnishee order of 1 day, and the banker has paid all the amount to the customer, and if there is no account, so then it is going to be very difficult for the banker to control that one. Customer account shows debit balance. Securities deposited in the bank are in the safe custody of the bank. Banker's obligation. Banker's obligation is nothing but obligation to honor the customer's check, obligation to maintain secrecy of customer's account, obligation to receive check and other instruments, obligation to honor check customers across the counter, obligation to give reasonable notice before closing the. These are the 5 obligations are there where banker's obligation related with the customer. So now there will be 10 marks question. Write all the 5 obligation and explain. For each point you have 2 marks. Obligation to honor check. See, these are the things which have to be written here. Condition to honor: there should be sufficient funds. Funds must be properly applicable. Check must be properly drawn. In that one, date should be written, amount and signature, endorsement detail should be there. Checks presented within the time, that is business days and hours. Correctness of check and proper presentation should be there. Uncleared checks. If all these things are in the favor of the customer, then there will be no problem for the payment of the check here. Conditions to dishonor: when the customer has countermanded payment, stop it. When a customer has given a stoppage letter for the payment. When the banker has received a notice from the customer's death. So if they have received a notice from the family members of the customer regarding the death of the customer, so check can be dishonored. When the customer becomes insolvent, when the bank has received the notice of insanity, garnishee order, or notice of assignment from the customer, or closing of account here. These are the concepts what we have here. Next one, condition to dishonor checks: willingness of the banker. When the check is not properly drawn, the date is mistake, amount may be mistake, signature is mismatching. When the posted checks are presented, so today is 12th December, and if I present the check of 5th December, it cannot be passed here. When the undated or stale check is presented, they have not mentioned the date only, or they have made some changes in the date concept. When the checks is presented after banking hours, if I go into present check after 5 o'clock, they never make the payment for that. When the check is materially altered or insufficient funds are there, where some persons have joint account but the check is not signed by jointly. When account is maintained by A as well as B here, only A has signed and B has not signed, then the banker can dishonor the check. Obligation to maintain secrecy of customers account. Already I said that one. The banker should not disclose any information to the third party. Precautions to be taken by banker while furnishing information. The information should be given in general statement but not in the figures. Already I said that one. He has to give in a generally, there's a thing, it may be there. And information should be given honestly and confidentially. Information should be given by putting the word without responsibility. I'm not responsible for the information generated. Information should be given on phone. Information should be given in closed cover, preferably sealed. The banker can provide the detail only in a secured and safe manner to the court or the other person. Obligation to receive check and other instruments for collection. The banker has a right to receive the checks from the customers and send that checks to the collection from the other bank, where the paying banker is going to pay the amount to the collecting banker. Obligation to honor checks of customers across the counter. A customer can present the check, open check in any of the counter and withdraw the amount from the bank whenever there is a necessity. Obligation to give reasonable time before closing the customer's account. So the banker has to give a sufficient time, or the customer has to give sufficient time to close all the accounts of the customer if it is required, and there be no forcibility in closing accounts. Like for that example, according to banking law, a debtor and a creditor may terminate the relationship without any notice. There is no need to give any notice that I want to close account, or the banker will not give the notice, or the customer will not give the notice. They'll close the account of the customer. By providing proper reasons for the closure of customer's account, it has a right to close account without any notice. The banker has a right to close the customer's account without giving any proper information or notice to the customer whenever there is default. Thank you to all 5th Sem BBA students. In this session, we learned about the special relationship of the banker and customer, where there will be a 10 marks question compulsorily. Understand the concept and write it clearly. Thank you and namaste.